You staying home tonight?
I hadn't planned on it, no.
Plan on it.
Hello and welcome to the DUI Law Firm YouTube channel. I am Varn Chandola, the attorney here at DUI Law Firm, which represents clients in the Seattle, Bellevue, and Tacoma region of Washington State. Today I will cover the topic of DUI law as it relates to CDL holders. CDL stands for Commercial Driver's License. The DUI law, that is, which is applicable to CDL holders, is more stringent than it is for general drivers. And there are two basic reasons for this. One is commercial vehicles tend to be larger and heavier than general vehicles, and therefore commercial vehicles pose a greater danger to other vehicles and drivers on the road. And the second reason is that commercial vehicles frequently carry hazardous materials, thereby posing a greater risk for a catastrophic accident. Now, as far as the legal standard for DUI for CDL holders, the BAC limit is a .04. So if a CDL holder is driving a commercial vehicle and they have a .04 or above blood alcohol content, then that CDL holder is looking at an automatic DUI charge. For general drivers, the legal limit is a .08. However, for CDL holders, it is a .04. However, if a CDL holder is not driving his or her commercial vehicle, but instead is driving his or her own personal vehicle, such as his or her own automobile or motorcycle, then that CDL holder is looking at the same BAC standard as general drivers, which is a .08. So remember, the .04 BAC limit only applies if you are a CDL holder driving a commercial vehicle. However, for CDL holders, regardless of whether they are driving a commercial vehicle or their own personal vehicle, if they get a DUI, then they are looking at a minimum 1-year suspension of their license. And if they get a second DUI, it doesn't matter if the CDL holder was driving his or her own personal vehicle. A second DUI subjects the CDL driver to losing his or her CDL license for life. As I mentioned, there is a minimum 1-year suspension for a CDL holder who gets a DUI. However, if that CDL holder is driving a commercial vehicle that carries hazardous materials, then the suspension period is 3 years. Regardless of how much alcohol is in the CDL holder's blood, any trace of alcohol found in his or her blood will get the CDL driver a out of service order for 24 hours. So if any alcohol is found in a CDL driver's blood, that driver may not get a DUI charge if they're below a .04. However, that driver will still be facing a 24-hour out-of-service notice where they cannot drive their commercial vehicle for that 24-hour period. As far as marijuana consumption is concerned, if any trace of THC is found in the CDL driver's blood, and THC is the chemical found in marijuana that causes a pot smoker to experience a high. And so if any trace of THC is found in the CDL driver's blood, then that driver is looking at an automatic DUI charge. If you are interested in reading my blog article, which specifically covers the DUI legal standards for CDL holders, then there on the screen you will find the link to that blog article. Please feel free to access that to read it. Now, before I leave, I would like to give one final piece of advice to those who consume alcohol, and that is keep on trucking, but no beer chugging. And for those marijuana users out there, keep on trucking, but no pot sucking. Thank you very much for watching.